I think there's a fundamental misunderstanding in this motion to dismiss about what we're trying to accomplish here. We're not the major record labels. We represent both sides, the sound recording as well as the composition. Independent music creators have been left with no voice, no seat at the table. Truly, this is about making sure that a wrong that happened is made right. Suno responded to our class action lawsuit, and well, I'm shocked and I'm not shocked. I'm an intellectual property attorney, and this is one of those rare situations where I get to talk about one of my own cases because it's public record. And so in our lawsuit that was filed on behalf of independent music makers, we claimed two types of copyright infringement. And what we received is a motion to dismiss. And I want to talk about what this says. So in our counts for copyright infringement, we said, number one, Suno has already admitted publicly, unapologetically, that it's taken, quote, tens of millions of songs from publicly available platforms, whatever that means, to train its AI, which we allege is copyright infringement if you don't pay the requisite licensing fees. So that was number one. They're not fighting that with this motion to dismiss. They've already admitted that's what they did. Initially, with the major record label lawsuit that was filed against them, they came back and they said, we think it's fair use. We think that we were okay to do that. So that's basically the meat and potatoes of this entire lawsuit. But there is a second count. The second count for copyright infringement we pled was upon information and belief that AI, right, that the Suno AI was actually and has been spitting out either exact or almost exact replicas of the artist's music that we represent. Again, it did so without getting licensing. Now, I really want to stress this. I want to bring it home, okay, because I think there's a fundamental misunderstanding in this motion to dismiss about what we're trying to accomplish here. We're saying that the meat, the potatoes, all the good stuff has to do with the original downloading of music without authorization to train the AI. Can't do it. And in fact, Copyright Office says can't do it. Other federal courts say, again, can't do it when you're stealing music or creative stuff. Right now, we're not even having a fight about that. We're going to have a fight about what I'm going to qualify as the side of carrots to the main entree, which has to do with was there and has there been duplicate look-alike versions of your guys' songs, you the independent music creators, of your songs that were created by Suno either intentionally or unintentionally. Now, where I do want to kind of start with this is that in Suno's motion to dismiss, they called us a tag-along lawsuit, meaning we tagged along after the major labels filed roughly a year ago. Let me stop you right there. So since the beginning of time, independent music creators have been left with no voice, no seat at the table with any meaningful, important conversation about how the music businesses run, how these companies that just become prolifically large and well off financially, how they all grow on, well, our music, right? The music of really the most valuable and vulnerable members of the music industry. So we said that in the original complaint. That's why we're here today. So in the motion to dismiss, right, for Suno, they're notably not attacking the first copyright count. They're attacking the second one. The way I took it, they're essentially saying that we're not going to be able to prove that Suno, again, whether intentionally or unintentionally, was creating exact or almost exact look-alike songs. Now, because this is going to be a case that goes on for a while, I get to talk about this, but I have to be careful because we're in the process of talking about and working on what our response is going to be. And as much fun as it is for me to talk to you guys about the evidence, which is what we're gonna do. So I'll tell you what, if you're new to this channel, make sure you subscribe right now. What I'll say is that, well, we can point to something that has already been talked about, which is in the major label complaints. If you guys remember, we went through them. Not just Suno, but music AI platform Udio also got sued. And in that, they identified hundreds of instances where the AI was producing near identical outputs of its music. And so you might be thinking, well, then why didn't the major record labels sue for that second copyright infringement to say basically the AI made look-alike songs? And I'll tell you why. It's because major labels, when they acquire music, they acquire the masters. Let me give a little clarification on this. With music in general, there's two sides of it. There is the master side, which is the final recorded version, right? You're Tina, you're going into the studio, I'm pressing record. That final version that we then put onto Spotify is the master. And when major labels sign Tina, Universal signs Tina, Universal takes ownership of the master. But there's another side of the song. There's the composition. The composition is Tina's lyrics, her chords, right? All of the fundamental underlying intellectual property. And Tina gets to keep that. And one of the beautiful examples of this is actually Taylor Swift, right? So Taylor Swift got into a whole battle with her label. Well, I should say in a whole battle trying to get possession of her masters again. She couldn't even buy them back, okay, because they weren't being reasonable and all stuff. So what she did is that she eventually just went and re-recorded the songs because she still owns the songs. She owns the lyrics, she owns the chords, all the things that she made. So that's how it works. And so I can't speak for the major record labels, but I can assume the reason why that they don't have the second count, whereas we do, is that, well, our artists own their compositions. But I still love that we can point to the major record label complaints where they identify in hundreds of instances that Suno, in fact, created identical or almost identical outputs. Let me actually pop on over to the motion to dismiss. All right, so this is part of where in the motion to dismiss filed by Suno, they are talking about this word derivative, right? So they point to a couple of things. They go, every court has confronted the issue, or that has confronted the issue, has concluded that just because outputs of an AI model are in the plain English sense derived from a set of copyrighted works does not mean that the outputs of the model are all prima facie infringing derivative works in the copyright sense. Okay, so when we talk about derivatives, we're like something that is based on a copyrighted work. So let's, again, in the spirit of talking about songs, if you have a song and you go and remix that song, you have a new version of the song. And let's say there's an actual part of the original song in that remix. Okay, it's the vocals, it's the hooky guitar line. When you have a new version of the song, it's called a derivative work. It's a new thing. So part of what they kind of point to in this, they go, well, there's been other cases, and the other cases having to do where someone sued and they're like, the AI is making all this new versions of the creative thing that I made, and so all the new versions of the AI are infringing. I'm like, that's not what we're claiming here, but let's keep going. All right, so they point to some cases. They're like, hey, in these other cases, it didn't work out so well for them in this claim. And so they go, well, if plaintiff had identified particular sound-alike versions of their songs, right, which they haven't, that still would not state a claim for copyright infringement because the uniquely narrow scope of the rights Congress prescribed for sound recordings, specifically compared to all other copyrighted works, the only way a new recording can infringe the rights in a pre-existing one is if it borrows the actual sounds of the original. And this is where I feel like I lost Suno. So basically what they're saying is they go, pursuant to the Copyright Act, it says if you don't actually use a part of the sound recording itself, right, the master in the new thing, it's not a derivative, it's not infringing, it's not whatever. And I go, we're not the major record labels here. We represent both sides, the sound recording as well as the composition. So this is how it goes. I was talking about Beyonce recently and how Beyonce on one of her records, she had to go get licenses because she wasn't sampling. She wasn't taking parts of other people's songs. She was interpolating. And interpolation requires licensing. So meaning you take someone else's essence of their song. And a great example is if you just literally redo someone's song as if it was like a cover, but then you change like a whole chorus and the chorus is brand new lyrics, right? You have a whole new thing. And so you've changed it. It's no longer a cover song. It's a brand new iteration that you have come up with and all this good stuff. So in the land of interpolation, again, this is where we get into, it's very important. We're representing both sides here. Whether there was sampling, whether there was interpolating that was happening by the AI, well, we don't know just yet. But let's go back to the motion to dismiss. He goes on to say, this is not how Suno's tool works at all. So meaning it doesn't allegedly just spit out samples. This is not how Suno's tools work at all, as plaintiffs know. No Suno output contains anything like a sample from a recording in the training set. So no Suno output can infringe the rights in anything in the training set as a matter of law. So this is where I need to bite my tongue just a tiny bit. I'm very excited to come back to this exact sentence when we do file our actual response, but this is what I'm gonna say. This is a long battle. We have our plaintiffs who have been joining. If you're an independent music creator and you want to be a part of this, please go to indieailawsuit.com. You can also sign up just to get updates of all the good things to kind of support what we're doing here. There's been quite the movement on this, but truly this is about making sure that a wrong that happened is made right. Now, this is a very important piece, and I'm going to speak to AI artists on this specifically, because I've seen that AI artists have been getting badmouthed online. I don't like it. That's not what we're about with this lawsuit. I think people who are using these platforms, and even my clients, particularly my clients who use platforms like this to express themselves, people who have had entirely different careers, who are now at a point in their life where they are like, I just wanted to revisit my poetry and all these good things. I am very much about the mission here, which is when there's theft by a big corporation, and that big corporation is stealing from an independent music maker that otherwise should have received a license, should have paid for a copy. You don't get to do this, and you don't get to get away with it. And again, I come back to independent music creators have never had a seat at the table, but now I'm here. So drop a comment down below. Don't forget to sign up to be a plaintiff. I'll see you on the next one. I'm Top Music Attorney.